they are neither part of the government nor constitutional, but there are many differences. One difference is that in Supreme Court there are no alternates seated. The members of the court are recused from the case or not able to participate in the matter for reasons such as illness. For the Judicial Council, though, the church has provided a system whereby alternates may be seated when members of the council cannot attend. A clergy alternate is seated in place of a clergy member, and a lay alternate is seated in place of a lay member of the council if the circumstance occur. In the matter immediately before us, such a circumstance has occurred. A member of the Judicial Council, that Kiban, is now with us. A lay alternate, Warren Pardon, will participate in this oral hearing. Shortly, I'll be asking all 9 of us to introduce ourselves. But before doing so, I will outline the procedures for this oral hearing. The item known as docket item number 04171 is a request from the South Central Judicial Conference for a declaratory decision on application, meaning, and effect of paragraphs 304.3, 310.2d, 341.6, 2702.18b and d of the Book of Discipline 2012 in regard to the nomination, election, consecration, and or assignment as a bishop of a person who claims to be self-avowed practicing homosexual or is a spouse in the same sex marriage or civil union. According to the rules of practice and procedure of the Judicial Council, requests for oral hearing may be approved at the discretion of the President of the Council. In fact, most matters before the Judicial Council do not include oral hearings, and not all requests for them are granted. In this matter, having approved the request for oral hearing, I will describe the procedures. The petitioner named the South Central Judicial Conference will have 60 minutes to present this argument. Normally, in an oral hearing, the opposing side will have the same amount of time, except for the fact that the petitioner may express a desire to reserve 5 minutes of the allotted time for rebuttal if that desire is made known at the end of the petitioner's presentation. After each party has concluded its presentation, members of the Judicial Council will pose questions to the presenting party. We will strive to be good stewards of our time in asking questions, and we hope you will likewise do so in your replies. We have allotted a maximum of 2 hours 10 minutes for this oral hearing. Before my colleagues at this table introduce himself, I will offer a few words of the oral hearing. It is a public event, as you can see, you are all here. But at no time does the Judicial Council permit comments from any person other than distraction. We will recess the oral hearing in this room and hold the oral hearing open to all the members of the Judicial Council. Aware that this would deprive so many of the opportunity to witness the oral hearing, we will only do this if we cannot maintain decorum and offer full attention to each party as they make their presentation and respond to questions from the members of the Judicial Council. Next, if you have an electronic device with you, this is the perfect time to reach into the pocket or purse and silence the machine. Lastly, I want to remind all of the presenting parties that you have to address the Judicial Council, not each other. This is the Council's hearing, so you are speaking to us. I would now invite my colleagues to introduce themselves, beginning with the Vice President of the Judicial Council.
This is J. Ruben Reyes from the Philippines Annual Conference.
Louis Tran, clergy member, California Pacific Annual Conference, Secretary of the Judicial Council.
Good morning. Dennis Blackwell. I'm the lead pastor at Great Methodist Church in Woodland, New Jersey, and I'm glad for the resurrection.
Good morning. I'm Lydia from Africa and Mozambique, Costa Sanoa, Bishop Nyamala, a member of this council, Judicial Council. Thank you.
I'm Boyette from South Georgia Annual Conference, and I'm the first play all.
And I'm the clergy member, Norway Annual Conference.
Good morning, I'm Danielle Taha, and I'm a lay member from the Great Plains Annual Conference.
Good morning. My name is Kabamba Kiboko, originally from the Democratic Republic of the Congo, serving as lead pastor of Photoshop United Methodist Church in the West Ohio Conference. Happy to be here and happy to see you.
Thank you. In conclusion, we recognize that there are literally tens of thousands of Nigerians in prayer for this council and its deliberations. We give thanks for this prayerful support and offer our welcome to you here today as our prayer partners with United Melodies around the world. I would now invite the Secretary of the Judicial Council, William Trump, to lead us in prayer.
Please join me in an attitude of prayer. Oh, gracious God, we pray for your holy church, that you would be pleased to fill it with all truth and all peace and justice. Where it is corrupt, purify it. Where it is in error, direct it. Where in anything it is amiss, reform it. Where it is right, establish it.
Thank you, Jesus.
Where it is in want, provide for it.
Thank you, Jesus.
Where it is divided, reunite it.
Oh, yes.
Where it lacks wisdom, guide it.
Yes.
For the sake of Him who lived, died, and rose again,
Oh, yes.
and ever lives to make intercession for us, Jesus Christ, your Son, our Lord and Savior.
Hallelujah.
Amen.
Amen.
Now I invite the petitioner.
Good morning to the members of the council and to all who have come to these proceedings. My name is Keith Boyette. I'm an elder in the Virginia Conference of the United Methodist Church, and I am an attorney licensed to practice law in the Commonwealths of Virginia and Kentucky. I'm grateful for the council's granting of our request for oral hearing in this matter. And I would like to reserve 5 minutes for rebuttal out of my time. I represent Dixie Brewster, a layperson from the Great Plains Annual Conference, who was a delegate to the 2016 General Conference and South Central Jurisdictional Conference. Ms. Brewster was the maker of the motion before the 2016 South Central Jurisdictional Conference requesting the declaratory decision, which is before this body. That motion was made on July 15, 2016. I'm confident that you are aware of its words, so I won't read it to you. The motion was adopted by the South Central jurisdiction by a vote of 109 to 94, a 53.6 majority. In our brief, I have provided you with a link to a video of the floor debate and the taping and announcement of the vote on the motion. Contemporaneous with the adoption of the motion, requesting a declaratory decision by the South Central jurisdiction, the Western jurisdiction elected Reverend Dr. Karen Olavito as the Bishop of the United Methodist Church. Bishop Olavito, since October 1, 2014, has been and continues to be a spouse in a same-sex marriage, according to a public record obtained from the clerk's office of the County and City of San Francisco, California. We attached a copy of that certified record as Exhibit 1. Bishop Oliveto has publicly affirmed in media that she has performed more than 50 ceremonies celebrating homosexual unions or marriages, knowing that the performance of those ceremonies violated the provisions of our Book of Discipline. And she has acknowledged that she has been able to do so because she has had the support of those who have supervisory responsibility over her ministry. The 2016 Western Jurisdictional Conference was well aware of this reality when they convened, as they took time during their conference for conversation about the impact of electing an openly homosexual person who is in a same-sex marriage to the episcopal office. The questions presented by the South Central Jurisdictional Conference and the decision of the Judicial Council may have an impact on the ability of Bishop Oliveto to continue to serve. The Judicial Council has jurisdiction over this matter under paragraph 2610 of the 2012 Book of Discipline. The 2012 discipline grants jurisdiction to the Judicial Council to make a ruling in the nature of a declaratory decision as to the meaning, application, or effect of the discipline or any portion thereof. The South Central Jurisdiction's request falls within this jurisdictional grant as it seeks a ruling on the meaning, application, or effect of identified portions of the discipline to an action of a jurisdictional conference. Thus, with respect to the subject, the matter is proper. The party requesting this declaratory decision is also proper. Paragraph 2610.2F provides that such a request can be made by, and I quote, any jurisdictional conference on matters relating to or affecting jurisdictions or jurisdictional conferences or the work therein. Here the party requesting the declaratory decision is a jurisdictional conference, and the subject of the request relates to matters affecting jurisdictions or jurisdictional conferences or the work therein. The request addressed the nomination, election, consecration, and assignment of persons as bishops of the United Methodist Church, which is the primary and exclusive work of the jurisdictional conferences in the United States. Each jurisdiction has an interest in how other jurisdictions interpret and apply the discipline to the process of nominating, electing, consecrating, and assigning a bishop, because we are a connectional church, because a person elected to the office of bishop is a bishop of the entire church and is eligible to serve within the confines of any jurisdiction of the church. When elected a bishop, that individual joins his or her colleagues as a chief executive officer of the entire church. That person has the opportunity to serve as a presiding officer at the general conference of our church. That person nominates clergy and laity to serve on general church boards and agencies. And that person can serve as chairperson of our general church boards and agencies. The Judicial Council decisions and memorandum relied upon by the respondent here and other amicus curiae to assert that there is not jurisdiction in this case are distinguishable from the present matter and do not preclude you from granting jurisdiction here. In fact, if you review each of those decisions, as I have in our reply brief, you will see that in almost no instance do the matters involve the work of the entities that were involved. And that was exactly any of the entities. If it was an annual conference, if it was a jurisdictional conference, or if it was the General Council of Ministries, the matter raised in each of those cases did not pertain to the work of any similar body. This does. Here, the Judicial Council should adopt the cogent reasoning and declaration of Ruben Reyes in his opinion in Memorandum 1200. There, Mr. Reyes wrote these words. In that case involved an annual conference. In order for an annual conference to gain access to the Judicial Council via petition for declaratory decision under paragraph 2610, it is sufficient for jurisdictional purposes that the subject matter relates to the annual conferences or their work. Do I need to stop for a moment?
Continue, please.
Okay.
Sorry for that.
It is sufficient that the jurisdictional purpose is that the subject matter relates to the annual conference or their work. Here that would be the jurisdictional conference and their work. Not necessarily to the petitioning conference. The matters taken up need not be peculiar, exclusive, or confined to the business, agenda, or work of the petitioner annual conference. And I would note as an aside here, that is a major distinction in the jurisdiction that you have in a declaratory decision matter versus a bishop's ruling of law. There, the jurisdictional scope is different. Continuing to quote Mr. Reyes, it may also relate to or affect other or all annual conferences, especially those similarly situated. We would substitute jurisdictional conferences there. The door of the Judicial Council ought to be open to an annual conference initiative concerned not only with their own valid interests and causes, but also with those of other annual conferences, jurisdictional conferences. Continuing to quote, notice to be keenly taken on the plural form of the connected critical terms in subparagraph 2. The settled pertinent rules of statutory construction mandate that words should be given their ordinary meaning. General words should be understood in their general sense when the law does not distinguish. Courts should not distinguish. Annual conferences certainly include one, some, or all such level of conferences in the church, and the same would be true of jurisdictions. To continue to quote, this construction requires cogency because a petition by an annual conference for declaratory decision pertains to the constitutionality, meaning, application, or effect of the discipline, or part of it, or any act or legislation of the General Conference. In principle, such a decision on constitutional or disciplinary issues raised by a petitioning annual conference, jurisdictional conference, has a repercussion on many or possibly all annual conferences, jurisdictional conferences. Considered with our vital tenet of connectionalism, it is discernible that what affects one can affect all, particularly of the same jurisdiction or region. What is good policy for one conference would likely be good for others in the same situation. What salutary principle applicable to one may apply to all. That hopefully will redound to the good order and discipline of the annual conferences of the church linked together worldwide. End of quote. The same reasoning applies to the jurisdictional conferences. Now, this council, almost 20 years ago, held in Decision 886 that the Judicial Council, that the discipline is the law of the church, which regulates every phase of the life and work of the church. As such, annual conferences may not legally negate, ignore, or violate provisions of the discipline with which they disagree, even when the disagreements are based upon conscientious objection to those provisions. The Judicial Council has held that the holding of Decision 886 is applicable to the jurisdictional conferences of the United Methodist Church. In Decision 1250, the Judicial Council reviewed a resolution that was adopted by the Western Jurisdictional Conference titled Sense of the Western Jurisdiction of the United Methodist Church, and which sought to establish by legislative action of that conference the penalty if a bishop was convicted of violating the discipline. The resolution provided that in such a case, the appropriate penalty would be a suspension of the bishop from the exercise of the episcopal office for a period of 24 consecutive hours. And the Judicial Council in Decision 1250 stated, a conference, jurisdictional, central, or annual, may not legally negate, ignore, or violate provisions of the discipline. In Decision 886, the Council observed that such acts negating, ignoring, or violating the provisions of the discipline, and I quote, would leave the church without any enforceable law, which would lead to chaos in the church. The principle set forth in Decision 886 has been applied in numerous cases by this council to invalidate actions of both annual and jurisdictional conferences. And I've cited a number of them in our brief. Decisions 9/11, 11/11, 11/15, 11/20, 11/85, and 12/50. In each of these instances, those actions have involved resolutions directing individuals or entities to take actions which would negate, ignore, or violate the discipline. However, the action addressed here is even more pernicious, because a jurisdictional conference, if it were permitted to proceed to nominate, elect, consecrate, and or assign a person described in the declaratory decision request, that jurisdictional conference would be immediately in violation of the discipline. In such an event, this council is the only body within the polity of the United Methodist Church which has the ability to rule that action to be unlawful, null and void, and no effect. The words of the Judicial Council in Decision 886 have proven to be prophetic in the United Methodist Church, where the actions of various jurisdictional annual conferences negating, ignoring, and violating the provision of the discipline leave the church without any enforceable law, and where the church is in chaos with its very unity threatened. The only remedy left to those who would uphold the discipline in the face of such willful disobedience is to seek redress from this council. The circumstances on which this declaratory decision is requested by the petition has in fact now occurred with the actions of the Western Jurisdictional Conference. Representatives of the Western Jurisdictional Conference have been identified as interested parties, including Bishop Olavito, who has been nominated, elected, consecrated, and assigned in violation of provisions of the discipline. Therefore, if the Judicial Council holds as requested, the actions of the Western Jurisdictional Conference in nominating, electing, consecrating, and assigning Bishop Olavito would be an action which would negate, violate, and ignore the provisions of the discipline, and under Decision 886 would be null, void, and of no effect, resulting in the invalidation of Bishop Olavito's election. The United Methodist Church has positively defined what marriage is for the United Methodist Church. Marriage is explicitly defined as being a relationship between one man and one woman. Paragraph 161b of the discipline states, and I quote, "We affirm the sanctity of the marriage covenant that is expressed in love, mutual support, personal commitment, and shared fidelity between a man and a woman. We support laws of civil society that define marriage as the union of one man and one woman. This definition of marriage excludes all other definitions of marriage and makes such other definitions unlawful in the United Methodist Church. Thus, when the New York Annual Conference sought by conference action to permit clergy to enter into same-sex marriage in contravention of the discipline, the Judicial Council in Decision 1185 held that the New York Annual Conference had acted in such a way as to negate, ignore, and violate the discipline. In other words, any form of marriage other than that defined by the General Conference of our church in the discipline was unlawful under our church's polity. In Decision 1185, this council stated, and I quote, The General Conference has legislative authority for all matters that are distinctly connectional, and is the only body authorized to define legislatively the words lawful and married. The General Conference is the only body empowered to adopt legislation. The General Conference has done so, including paragraph 161B, in defining marriage by limiting it to the marriage covenant that is expressed in the love, mutual support, shared commitment, and fidelity between a man and a woman. The Council said this definition is within the power and the authority of the General Conference to define marriage for the entire church. This Council proceeded to note that the New York Annual Conference's resolution and policy there under review was, and I quote, aimed at permitting clergy who wish to enter into same-sex marriage to do so at their discretion. Paragraph 604.1 provides, and I'm quoting, that an annual conference for its own government may adopt rules and regulations not in conflict with the discipline of the United Methodist Church. The action of the New York Annual Conference, the Court Council wrote, in adopting Resolution 2010-305 is a violation of paragraph 604.1. This resolution and policy could arguably be advanced as some safe haven from the complaint process for those clergy who choose to enter into a same-sex union at their discretion under the auspices of the proposed resolution and policy. Quoting, the annual conference has no authority to offer clergy immunity from administrative or judicial complaint processes by adopting a resolution and policy that is contrary to the discipline. This Council, in Decision 1185, concluded, and I quote, the Church's definition of marriage as contained in the discipline is clear and unequivocal and is limited to the union of one man and one woman. As a consequence, any other form of marriage not limited to the union of one man and one woman is unlawful in the United Methodist Church. As the Judicial Council noted in Decision 1185, paragraph 2702.1a defines immorality as not being celibate in singleness or not faithful in heterosexual marriage by explicit action of the General Conference, codified in the discipline. Clergy in the United Methodist Church, including persons in the office of bishop, may either be single or in a heterosexual marriage. It is unlawful under the discipline of the United Methodist Church to be a party to a same-sex marriage. The Western Jurisdiction College of Bishops, in its brief, cites Decision 833 in arguing that a provision of the social principles is not the law of the church. But Decision 833, in fact, rules exactly opposite of that. There, the Judicial Council recognized that provisions of the social principles may indeed have the force of law, quote, notwithstanding its placement in the discipline, and specifically held that a provision placed in the social principles prohibiting the celebration of homosexual union by our ministers or in our buildings had the force of law even though it was then lodged in the social principles. Decision 1185 holds that the definition of marriage contained in the social principles has the force of law. Not only that, our book of worship is, in its provision for marriage ceremonies, affirms the marriage of the union of one man and one woman. We'll see pages 116 through 133 of the book of worship. Paragraph 16.6 of the discipline states that as part of the full legislative power of the General Conference, it has the authority to provide and revise the hymnal and ritual of the church and to regulate all matters relating to the form or mode of worship. And they've done so through the adoption of the book of worship. The discipline further declares that an act of immorality by a person who is a bishop or clergy member of an annual conference includes but is not limited to not being celibate in singleness or not faithful in heterosexual marriage. Paragraph 341.6 of the discipline further makes clear that the understanding of the United Methodist Church that the General Conference has declared marriage to be a covenant between one man and one woman. Several of the briefs that have been filed by the amicus curiae in this matter assert that it's not unlawful for a pastor in the United Methodist Church to be married to a person of the same gender. And those arguments just simply strain credulity in light of what I've just referred to. Over the past more than 40 years, the General Conference has made clear that marriage is defined in a specific way. These amicus curiae that assert that the lack of a prohibition of other forms of relationship as a marriage would mean that the church permits those other forms of relationship. And under this reasoning, although our church's position is that the marriage is between two people, one man and one woman, it would be fine for persons of the United Methodist Church. They would assert under their logic to be parties to a polygamous marriage, because such a marriage is not explicitly prohibited in the policy of the United Methodist Church. And yet our church does not recognize polygamous marriages as being lawful marriages in which our elders can be participant. The public record that one person is married to another person inclusively establishes the existence of that marriage that's addressed therein. The nomination, election, consecration, and or assignment as a bishop of the United Methodist Church of a person who is a spouse in a same-sex marriage would be an act which would legally negate, violate, and ignore these provisions of the discipline. And as such, that action would be null, void, and of no effect. The discipline repeatedly makes clear that an ordained person, and thus a bishop, must be celibate in singleness and faithful in heterosexual marriage. Likewise, the nomination, election, consecration, or assignment as a bishop of the United Methodist Church of a person who claims to be a self-avowed practicing homosexual would manifestly negate, ignore, and violate paragraph 304.3 of the discipline, and would be, as such, be null, void, and no effect. Note that in these proceedings, the focus of the Judicial Council is on, hear this, the ability of the jurisdictional conference to take action, to elect a person as bishop, and the focus is not on the standing of that person in his or her ministerial office. The discipline does not guarantee any ordained person the right to be elected to the episcopacy. However, the discipline does guarantee ministers in good standing an appointment. And that was the key point in Decision 920, the guarantee of appointment because a person was a minister in good standing. There is no similar provision with respect to bishops. And in fact, I would urge you to read the paragraphs that deal with the election, nomination, election, assignment, consecration, and assignment of bishops. In none of those provisions will you find in the discipline the words good standing. If the Judicial Council determines, as contended here, that a conference is prohibited from electing to the office of bishop an individual, the election of which would negate, ignore, or abolish, or violate the discipline, and that election is null, void, and no effect, such a person would continue to be a member of the Order of Elders, would continue under appointment as an elder, and that person's membership in his or her ministerial office would be subject to review under the terms of Decision 920. Thus, if as requested, the election of Bishop Oliveto is declared null, void, and of no effect, Bishop Oliveto would still remain an elder in the United Methodist Church. She would be guaranteed an appointment, but the Western jurisdiction would have been prevented from taking an action which negates, ignores, or violates the discipline. All fair process and trial rights which attach to the membership and the order of the elders is safeguarded. Complaints are pending against Karen Oliveto already, placing her membership in her ministerial office as an ordained elder in the United Methodist Church under review. The last statement that was issued with respect to those complaints has been that they are in supervisory process. The initial 120-day period for supervisory process has expired, with no notification of an extension of that supervisory process or what the disposition of the complaints has been. Oliveto's right to trial, guaranteed by paragraphs 20 and 58, and fair process protection are ensured as part of the judicial process resulting from the complaints filed against her. With respect to the authority of bishops to consecrate a person where the election of that person has negated and violated and ignored the discipline, I would refer you to paragraph 403.1F of the discipline, which declares that bishops are elected from elders and set apart for a ministry of servant leadership, general oversight, and supervision. And then it goes on to say that in the ministry of administration, the role of bishops is to uphold the discipline and order of the church by consecrating persons in ministry of the church and the world. The argument of the Western Jurisdiction College of Bishops makes bishops little more than masters of ceremonies in such proceedings, saying that they have no ability to exercise this authority here. Charged with upholding the discipline and order of the church, the lawful actions of the bishops are defined by the Constitution and discipline. Just as conferences cannot negate, ignore, or violate the discipline, neither can our bishops in the performance of their responsibilities. As discussed above, the General Conference has preemptively declared the nature of marriage. Therefore, in their role as bishops charged with the ministry of administration, the upholding of the discipline and order of the church, it would be unlawful for a bishop or a group of bishops to consecrate a person who is known from the public record to be a spouse in a same-sex marriage or union. And if a bishop or a group of bishops did so, their action would be null, void, and of no effect. The public record of a same-sex marriage or civil union of a clergy person, we submit, is a self-avowal of the practice of homosexuality when it's brought to the attention of a bishop, a district superintendent, a district committee on ordained ministry, a board of ordained ministry, or the clergy session. There are many ways that information can be conveyed to another. Certainly a direct statement, either oral or written, is one way. And when such a statement is made to a governmental record, signed by the clergy person, and made public as an official record, it is sufficient to declare that which is contained in the public record. Anyone whose attention is brought to that record. Therefore, if a bishop, district superintendent, the various committees and boards of ordained ministry, or the clergy session become aware of that public record of same-sex marriage or civil union of a clergy person, the public record is an act of self-avowal of the practice of homosexuality. So we respectfully request that you answer the questions that have been propounded to you in the declaratory decision request by holding that the nomination, election, consecration, and assignment as a bishop of the United Methodist Church of a person who is a spouse in a same-sex marriage, that the hold that negates, ignores, and violates the provisions of the discipline. And that you further hold that such an election, assignment, and consecration would be null, void, and of no effect. That you make the same holding with respect to a person who claims to be a self-avowed practicing homosexual. That you further hold that a public record that a nominee for the episcopacy is a spouse in a same-sex marriage, if that public record disqualifies that person from nomination, election, consecration, or assignment as a bishop in the United Methodist Church. That you hold that when a person is known by public record to be such a spouse, the bishops of that jurisdiction cannot lawfully consecrate that person as a bishop and that their action in doing so would be null, void, and of no effect. And that you hold that a public record of a same-sex marriage or civil union of a clergy person is a self-avowal of the practice of homosexuality when brought to the attention of responsible bodies. And then finally, that the election of a person to the office of bishop, where such election is null, void, and of no effect, results in no change in that person's membership in their ministerial office, but subjects that person's membership in that office to review as required by decision 920. For these reasons, we ask you to hold that the nomination, election, consecration, and assignment of Karen Olivito as a bishop in the United Methodist Church is an action which negates, ignores, and violates the discipline of our church, and that you hold her nomination, election, consecration, and assignment null, void, and no effect. I will reserve the remainder of my time for rebuttal. Thank you very much.
Thank you, Brother Boyette. We now have questions from the Judicial Council.
In your presentation, you quoted paragraph 2610 of 2012 for the discipline and reference letter F, which in short order provides the grounds for jurisdictional conferences to raise issues on the correct decision. And it simply says just bring jurisdictional conference on matters related to affecting jurisdictions or jurisdictional conferences of the vote therein. Could you be a little bit clearer as to how the election of the bishop in the Western jurisdiction directly impacted the work of the jurisdictional conference that you're representing?
First and foremost, our argument is that it does not have to under that under that disciplinary language. And when you look at the cases that the Judicial Council has decided under that provision, that none of them in the holding of the case say that that's required. In that all of those cases involve situations where the work of a jurisdictional conference or the other entity, any jurisdictional conference or any other entity of the category wasn't even impacted. Each of them involved actions by other bodies that then the relevant conference or body was seeking to get a ruling on. And so we would argue that all of those cases that dismiss jurisdictional annual conferences asking declaratory decisions were decided on that ground, that the subject didn't affect anyone of that same category. But here, the direct impact on the South Central jurisdiction is that these kinds of nominations can occur from the floor at any time. And they did in the various jurisdictional conferences this year. And so it's appropriate for a jurisdictional conference to ask the question so that it will be guided in future proceedings as to whether or not such a nomination, an election, consecration, and assignment would be appropriate. But further, as I noted in my remarks, I've cited various ways in which the election of such a person, even in another jurisdiction, directly impacts the work of sister jurisdictional conferences across the world because of the all-encompassing authority of bishops.
Good morning, Reverend Boyette. Thank you for being here and thank you for your work and service to the church. May I ask you four related questions, one on jurisdiction standing, one on constitutional law, one on statutory law and judicial remedy. And relax, this is not the California bar exam. So.
Thank you.
Okay, jurisdiction and standing. Let's say if we were to grant jurisdiction on 2610.2L. My question is, what would prevent an annual conference from using the same provision in 2610 to file a petition for declaratory decision to challenge the clergy vote of another annual conference because they don't happen to like the ordinance, the candidates for ordination?
As as long as that request was related to the standards that were to be applied that are outlined in the discipline, and that's what was being sought for interpretation. It would be my submission that the wording of 2610.2 provides that one annual conference can ask for the meaning, application, and effect of a discipline to the actions of another annual conference as well. They're similarly situated. Now, if it simply doesn't go to the meaning, application, or effect, then I think that would prevent someone going behind what was done to look at the decision itself if it wasn't something that was obvious on the record as we have here.
Thank you. Question number 2. Let's talk constitutional law. Are you of the opinion? Do you believe that a bishop, reportedly or openly gay, has the constitutional right to due process under paragraph 20 of the Constitution? And if so, then that right has to be protected, and even if there's a violation, that the judicial and or administrative process has to be pursued for any further action.
I would assert that that right to trial applies to clergy persons and in their status in their various orders. And so here again, I would underscore that the focus is not on the activity of the individual. It is focused on the authority of the jurisdiction to take the action that was taken. I would maintain that the due process, fair process rights of the clergy person are protected by the proceedings that occur when a person's ministerial office comes under review.
I have my third question is related to the language of the disciplinary 27. In 02.1 regarding immorality. The question here is you would apply that. You would apply the chargeable offense of immorality to someone who's a spouse in the same sex marriage. The language doesn't seem to support that. How would you make the case for that? And also the case law interpreting and applying immorality. The latest case that comes to mind is Leslie versus Florida Annual Conference, and there's an older case, Kettle versus Rock Mountain Annual Conference, that interpreted immorality and also applied to a situation where the clergy was in a heterosexual marriage, but was unfaithful to his wife. What say you?
The language of 2702.1a is explicit. Immorality includes but not limited to not being celibate in singleness or not faithful in a heterosexual matter. I believe that language is clear about the type of marriage that is recognized in our church, and I'm citing that for the fact that in multiple places in our discipline, the nature of marriage has been defined, and that therefore an action by anybody in the church, here specifically a jurisdictional conference, that would recognize a marriage that is allow someone who's in a different type of marriage to function in that capacity would be an unlawful action for that body to take. So again, I cite that provision for the fact that we have consistently defined marriage as being a heterosexual marriage and between one man and one woman.
Thank you, Reverend Boyette. And my last question, if you please indulge me. Judicial remedy, the relief that you were asking is notification of nomination, election, consecration, and assignment of an openly gay bishop. My question is the judicial remedy, that particular judicial remedy allowed under 2610, given the constitutional right to fair due process under paragraph 20 of the Constitution and the pertinent case law?
Well, and my answer to that would be consistent with the prior actions that that action results from, the illegality of the action of the body, and what is being ruled null, void, and no effect is the action of the body, so the election never occurred. And so you're not trying, the person is already under charges, and they're pending with respect to their status in the ministerial office.
My question goes to the jurisdictional argument.
Yes.
And as a good constitutional scholar, I assume that you would concede that the Constitution takes precedence over other provisions, judicial conference, whatever.
Absolutely.
How do you square your jurisdictional argument with the powers granted under paragraph 27, article 5.1, which states, and I will ellipse this, the jurisdictional conferences shall have the following powers and duties and such others, within their boundaries?
To me, what that does is say where they can exercise the powers enumerated here within their boundaries, but this is not a power of challenging this, or challenging the meaning, application, and effect of these provisions in other jurisdictions. It's not outside that grant. I mean,
why doesn't that limit the declaratory decision portion that gives the right to jurisdictional conferences to raise questions within their boundaries?
Because the jurisdictional constitutional provisions are in the article on judicial procedures. And the General Conference, under those provisions, has the right to grant jurisdiction as it deems to this council, and has done so to say that jurisdictions may ask questions about the meaning, application, and effect of disciplinary provisions as they apply to in all jurisdictional conferences. Thank you.
So, Boyette, I have a question. As you are aware, the Judicial Council does not give advisory opinions.
Right.
Usually, the issues with rare parties and interest is something that is going on in full at the annual Central Judicial Conference. In the request, argument has been made that it is vague. There was no party. There was no action pending. No action being taken by your jurisdictional conference or any other jurisdictional conference. So that the request for declaratory judgment is not a most hypothetical.
That's the argument.
Can you address that?
Yes, I certainly would. I was going to reserve that for my rebuttal. So, that's an argument that the Western Jurisdiction College of Bishop makes. The question is moot if the controversy addressed by the question has been resolved or no longer exists. But this question still exists. It existed when the South Central jurisdiction adopted the motion for declaratory judgment, and it's made even more relevant now by the almost simultaneous action of the Western jurisdiction taking the action that it did. The continuing nature of the controversy is demonstrated by the floor debate that occurred and by the ongoing debate within the broader church. It's not hypothetical if it raises a real controversy, and if you go back and look at the declaratory decision request handled by this council, where a specific situation is described, as is here, a person nominated for the office of bishop who is in a same-sex union, this council has consistently held that those kinds of controversies are real controversies and appropriate. All you have to do is look at decision 886 to see a question that was broad in context. It did not refer to a specific instance or specific people, where this council ruled the very principle that is at the core of this. I would submit that the specific facts necessary to decide this are before you, and the inquired upon legal consequences are real and before this council as well.
I want to know if the petitioner, which is Brewster is here?
Yes, she is. She's right here. Would you stand?
May I know if Bishop Oliveso is present?
She is. Video is every rest.
Okay, that's all.
Boyette, again, back to the jurisdiction, the question of this council having jurisdiction. Just going to share with us what was it about the visit to the annual conference that would make a request for declaratory decision to manage the business that was taking place?
Again, I would argue that that's a requirement that is applicable to requests for decisions of law. It's not a requirement that's relevant to declaratory decision requests, but the nomination, election, consecration, and assignment of bishops is the primary function of jurisdictional conferences. It's about all the business that they do.
Thank you, Mr. Wade.
Thank you very much.
We're not adjourned for 15 minutes.
Perfect. We sooner than expected. After 15 minutes, we'll be at somewhere and we'll listen to the respondent.